Hello, and welcome to the 20th edition of Questions for Lawyers. I'm your host, personal injury attorney Jeff Adelman, and with me today is my good friend and former adversary, Doug Melamed.
Whatever.
I got distracted by the door. Doug Melamed of Banker Lopez Gassler. We've litigated against each other before. Our kids have been in the same class in elementary school,
And we're still friends.
And we're still friends. We had a very interesting case many moons ago involving a murder in a restaurant, and brought up so many different aspects of a negligent security case, and we got to know each other pretty well through that. And I'm just thrilled to have you here, Doug.
It's great to be here. I'm really looking forward to this. You've done an excellent job of stimulating interest in the legal profession, and you're just doing a great thing for the community.
Well, thank you, Doug, and I appreciate you responding to my text. We're all wearing our blue today in celebration of the St. Louis Blues' first Stanley Cup championship. I know you're a hockey fan, and
yes.
I'm excited for the people of St. Louis.
Absolutely. It's nice to see a city and a franchise win that hasn't won in a long time.
Absolutely, or ever. That team's never won.
Boston can go without it. They've got the Patriots.
And the Red Sox. And they'll probably win again this year, too. So they can drown in the sorrows of their memorabilia from those championships. Well, Doug, the reason why I felt it was important to have you on the show is the audience has heard my perspective from a plaintiff's perspective, somebody who represents people who are injured on different premises, different stores, different businesses. But you're on the other side of that. So I thought it would be helpful to have your perspective of these cases, and also some advice that you could give for some small businesses for prevention, and also what to do if something happens.
Absolutely.
Okay. Well, for starters, can you tell us what type of cases you defend?
Yes, well, I work under what's considered an insurance defense umbrella, which can be a lot of things. I do mostly civil and commercial trial litigation. I represent businesses, self-insureds. They could be shopping plazas, restaurants, bars, daycare centers, hospitals, any kind of business. It could be a small business owner. It could be a large shopping mall. It could be the tenant in a plaza. It could be the owner of the plaza, the property management company. And there's so many different kinds of cases and lawsuits that are filed. They're all under a general negligence kind of standard, but the cases are all so interesting, which is why I love what I do.
Well, and you're very good at what you do from my experience dealing with you. Tell me, most of the time, though, when you are hired, how does it work? Is it through the business itself would contact you, or would it be like an insurance carrier?
Most of the time it's through an insurance carrier. And, every business, if you're in business operation, you need to have commercial general liability insurance. It's a CGL policy. And every business owner, every tenant, everyone should be going through their insurance agent and brokers to procure coverage for their premise in case something happens to anybody, an invitee, a person that comes onto the premises and gets injured. And so most of the time when something happens where somebody gets injured, the business owner or the tenant, the landlord, they are placed on notice, and they should immediately send it off to their insurance company, who then retain us to represent and defend the business owner. And, sometimes people, don't have proper insurance. And so business owners or individuals can retain us as well to represent them. We represent people either through insurance companies or through their own retention.
Well, and again, I've gotten calls before where people are needing defense, and usually the first thing I will ask them is, do you have an insurance policy? You should notify your carrier. Do you agree with that?
Absolutely. I mean, that's the first thing. If you get notice of an incident or you get mail about it, immediately contact your insurance agent or broker and have them put the insurance company on notice so that they can properly protect your rights.
In fact, if you don't put them on notice, there could be a negative consequence to them if they don't.
Well, part of the thing that people don't understand is when you get an insurance policy, and that could be in almost any situation, even as a homeowner, for your auto, or as a business, you have to read the policy, at least skim it over to understand what your rights and expectations are. The insurance company is going to want to know when something happens, and you have to put them on notice in order to be protected. If you don't, if you try to hide it, if you try to bury it, it's not going to stay buried. It will come out, and the insurance company can deny coverage to you if you interfere in it or impede in their ability to have provided representation.
Absolutely. Well, to those small businesses who may be watching right now, maybe they have a restaurant or a coffee shop, or they sell merchandise. What are some basic things that you could recommend to a retailer that they can do to either prevent an incident from happening or make sure that they're covered, and that, if something does happen, that they're properly documented?
I'm sure you've talked about this from your perspective, your end of things in the personal injury realm. People go on to premises all the time and they get injured sometimes. And what business owners, whether small or large, can do is have a regular routine of inspecting their property, whether it's a small store, a small business, or if you're a shopping center, a building owner. Have a routine where you're walking the premises, walking the property, and inspecting to make sure that there are no dangerous conditions around. And you want to make note of that. If you have a log, if you have a journal where entries can be made as to something that's found, that you then contact your maintenance staff, or you hire somebody to come and make a repair to something that needs to repair. You always, as a business owner, have to be vigilant about the fact, not just running your business, not just the operation of your business, but making sure when people come onto your property that they are safe. Because in premise liability, the standard for the standard of care is that an owner, a property owner, or someone in control of a property has a duty to maintain a reasonably safe premise and a duty to warn of dangers that Joe Public, who comes onto the property, may not know about. So you have to always look for those things. You have, and that could be, something as simple as the walkway outside your store, or it could be in the parking lot, potholes or wheel stops that are defective and broken. Sure. But it can also be inside your store where something is not set up right and it causes an impediment to the walkway area where people can get injured. I've seen it all kinds of cases.
And it doesn't take a long time to really just do a walkthrough and see if there's anything where you could imagine somebody getting hurt. And that's really the standard, right?
It is. It's interesting. We all think about Publix and think about the banana peel, or think about the jar of sauce that drops in aisle 6. You have a duty to walk around and inspect, but
you take a little water. I know you're battling something today. We appreciate you being here and giving us a lot of good information. We got to take some water breaks.
I like to talk, but and hopefully my voice will hold up for today. And I apologize for people listening if I don't sound that good. But think about this. The standard is not to maintain a perfect premise. Nobody can be held to the standard of maintaining a perfect property. But you have to create some kind of a system where you're every 10, 15 minutes in a supermarket, or on your property every hour, at least looking around and noticing for certain defects. You don't want that banana peel sitting on the floor for an extended period of time.
Right. Yeah, because if it is, then that's what I'm going to argue, that
exactly.
It's brown and it's been there a long time. Whereas if you actually found it to begin with, or we're doing regular inspections, that kind of brings the notice requirement. It helps that argument on the defense side.
Right.
Okay. Well, how do you feel about surveillance cameras within the premises?
Surveillance is it's very good. There's no harm in it, especially today when surveillance equipment is cheaper than it was in the past. You can a property owner, even tenants, can put video surveillance cameras up on their property to record what's going on either outside or inside. And I've been in cases where you go to the video surveillance and you see something clearly happen, and it will help determine that the case should be resolved pretty quickly. But we've also been in cases where, uh, conversely to what somebody is claiming, the video shows what really happens, and it helps uh, eliminate the potential for fraudulent cases, which I think is very important because there are a lot of lawsuits filed. Some of them are real, some of them are not, and we have to weed through to find out what is a real negligence cause of action and what is just someone's um, made up story, or it didn't happen the way that they're claiming it happened. And video surveillance is very important because um, owners should know, and property owners or tenants, people that own businesses should know that um, video surveillance sometimes records over itself after 48 hours or
Right.
1 week.
The
loop. And so if something happens, one thing that you should do is right away go get the video surveillance from that incident and save it, preserve it. Because if somebody gets injured and you have video, an attorney sometime down the road is going to try to make a demand that you preserve that evidence and that they see it. So you should hold on to it, save it right away, and then give it to your insurance company.
I had a case many years ago. I don't know if you know him, Sandy Topkin.
Yes.
But it was a case against a supermarket, and we were fighting like hell in this case. And finally, he says, "Jeff, come to my office. I want to show you the tape."
Yeah.
So we watched the tape, and I actually saw moments before it happened, my client poured something on the ground. Needless to say, we got the case done.
Right.
But had he not had that video, had the supermarket not had that, I would have kept fighting like hell, because I have to believe the client. But there's no better evidence than a video like that.
Agreed. And I have another story. And like I say, my practice is so diverse, and I love the cases that I get, because it could be anything. I represented one of the local casinos, and they have video surveillance cameras all over the place. But there was a gentleman that moved a chair in the lounge area over to a particular area and was sitting there rocking on the chair, and was leaning back and collapsed, and brought a lawsuit claiming that we had a chair in the lounge area that was defective and shouldn't have been in use, and tried to claim all of these back and neck injuries. And we had video surveillance, and the lawsuit was filed. But once I sent it to the opposing counsel and I said, "Look at this," he agreed, and he dropped the case, and it was gone. And that helps prevent the fraud, because there are plenty, and I'll admit, there are plenty of real cases out there. Even as a defense attorney, I can say there are plenty of real cases out there where people are injured and it is because of someone else's fault. But we want to weed through the ones that maybe don't have a valid claim.
Absolutely, because again, it hurts the legitimate claims to have the fraudulent ones out there. So I was thankful that I didn't waste any more time or money on that case with Sandy Topkin. But in a situation, and you touched on it a little bit, claims filed, lawsuits filed, what would you recommend a store owner do as soon as that happens, other than what you've already said?
Well, first steps first. If something happens on your property that you know about, if a fall happens, if somebody is injured, and that EMT paramedics are called to the site, you as a business owner, a property management company, the tenant, you should immediately go to the person who's injured, and first find out how they're doing. Try to help them as much as possible, making them comfortable until help arrives. But you should get some information. Take photographs of the scene, excuse me, of the
Absolutely.
scene, and get a statement. Most businesses have some kind of an incident reporting form. And I would recommend to each business to maintain one of these, some kind of an incident report. Incident reports are privileged. So you can take down information and it's for your business purposes. It's a business record. It's for you to write down information about what happened. Take down witness names, take down information, name, address of the person that was injured, take down anything that they can tell you about what happened, and hold on to that form. It's not something that has to be given to the person who's injured. It's for your internal records. And I would recommend you fill one of these out and you hold on to it again in case a lawsuit is filed. You're going to want to get that along with video surveillance to your insurance company. Because the insurance company will eventually retain me to represent you, the business owner. And so you want to fill out an incident report. You want to get the names of witnesses who saw something. You want to take photographs, and you want to go immediately to your video surveillance cameras and make sure you save the clip of the video.
You mentioned something, and I want to touch on it with work product privilege.
Yes.
Okay. Let's just say it's very obvious that there is negligence, that the store did do something wrong. They could actually write on that report, the stuff was on the floor, the water was on the floor, we didn't look, it was our fault, anything like that. And an attorney like me cannot get access to that report. Isn't that right?
That's correct. Absolutely. I mean, the whole purpose is not to impede an investigation, even by the company, the property owner, the tenant who may be at fault. The tenant wants to write down everything, or the property, the business owner, they want to write down everything, including what they saw, what was there on the floor, the photographs. And that is key information for you as a business owner and your insurance company and the attorney to evaluate in determining when to settle a case, when to what the value of the case should be.
Yeah, because you want the honest impressions of the business so that you know whether or not to defend.
Absolutely. I mean, that's what our process is about. We take oaths as attorneys as officers of the court. That everything we do has to be within the rules of professional conduct, professional responsibility, and ethics. And so if something, regardless of whether it's good or bad, you want to know about it. The earlier you know about the bad, as well as the good, the earlier you can understand the nature of the case and whether it can be resolved. Because the last thing you want really in today's society is to go to trial not knowing everything, and one side is going to win, one side is going to lose, and there are consequences to that.
Absolutely. I try to tell my clients when I'm preparing them for deposition or anything like that, the worst thing is something I don't know about. I could probably guide you through any bad fact, but if I don't know about it,
exactly,
it's a bad situation.
Agreed.
Well, getting back to that whole theme of being transparent, being honest when you're dealing with your insurance company or writing a report, I want to talk to you about subsequent remedial measures. Now, anybody who's not an attorney out there has no idea what I'm talking about, but can you explain for the audience what exactly that means?
Sure. A subsequent remedial measure, it's part of the Florida Evidence Code. And let's say that you as a property owner or business owner know or see something that is a defective condition, or let's say something happens. For instance, a wheel stop that's broken in the parking lot, or brick paver pathway that has bricks out of place, or potholes in a parking lot. If something happens to somebody where they get injured after the claim, after a lawsuit happens, or just after the claim is made, because people have 4 years to file a negligence lawsuit, so it could be a long time. You now know about that defect. You know that there's a dangerous condition on your property. So what you need to do is you need to repair it. You need to fix it. Patch up the pothole, fix the wheel stop, correct the defective walkway in front of your property. If you do that, You are protecting yourself from future lawsuits, but it's something that's considered a subsequent remedial measure. You've now fixed and repaired something, and evidence of that cannot be used against you in court. And I should say that with a little disclaimer, because there subsequent remedial measures, while not normally while they don't come in as evidence in court, it can come in if the defendant, if the property owner is fighting ownership or control of the property, or for impeachment purposes. So you don't, under most normal circumstances, you don't have to worry that by fixing something, it's going to be held against you that you're negligent, because that's not the standard. It doesn't go to prove negligence. The plaintiff still has to prove that you had notice and knowledge of this dangerous condition when they had their incident. And that's a different matter. You repairing it is what you're obligated to do to make sure nobody else comes along and gets injured. And then if you're going to present the position that, yes, we control the property, yes, we manage the property, that's not an issue, evidence that you eventually repaired it will not come into play in court.
And I mean, the legislature has that, codified in the evidence code.
Yes.
The reason that exists is really public policy. If there is a potential dangerous condition, it's in the best interest of everybody for that to be repaired. So to actually be able to say, what do you mean you weren't negligent? You fixed it. Then all these dangerous conditions, potholes, rebar sticking out, would just stay the way they are.
Right.
And that would make us a less safe society.
Agreed. And I see it all the time in premise liability cases where a property owner, a tenant, they may not know that something is wrong with the property. They may not know. There might be something that's against the Florida building code, something that is below standard, whether it's an obvious pothole or a broken wheel stop, or just a slight variation in a handicap ramp or a curb, the step off of a curb. Somebody may not know until something happens that there is something wrong, and then they have to get it repaired. You want them to now get it repaired because somebody got injured and brought it to your attention, but it's not going to be used against you as evidence of negligence that you should have known. So go ahead and make the repairs, be the responsible owner, property owner, tenant, and make those repairs to make it safe. You won't have any problems in the future, but also you doing that will not be held against you.
That's right. And listen to your attorney in terms of how to deal with that issue if you're deposed.
I agree. I agree with that wholeheartedly.
Well, Doug, there's so many different things we can talk about. I'm going to leave one more. I'm going to go into one more area that I find really interesting: waivers, release of liability, assumption of risk. Now, I know that you deal with those type of cases.
Yes.
Sometimes it deals with like trampoline fun zones and all that. What is the significance of those releases that we sign for our kids when they go into like a fun zone? Or I don't want to name specific places, but we all know what we're talking about, areas where children are doing physical activity.
Yeah, there's so many, and part of my practice, which I say I love so much, is it can involve almost any kind of claim. I've had the fortune of representing sports teams, Major League Baseball teams, athletic venues, fitness clubs, places where you can go to have fun and do adventurous stuff, whether it's from the small trampoline parks to go-karting to different kind of venues. We all know that when we go there, we are told to sign this release and waiver of liability. It's almost a requirement in order to gain entry into the place. A lot of the lay people don't read it and really understand it, but nevertheless, it can be upheld in court against you if something were to happen to bar your claim. Property owners should always have, or business owners who run these kind of events, they should always have a waiver and release of liability for the customers, the patrons, to sign. But what you have to understand, and this is where someone like me as a defense attorney can come into play, is that these waivers and releases of liability have to be clear and unequivocal as to the language in order to be upheld in a court of law. And sometimes more is less is more, so to speak. There are waivers and releases that can be a full page, 2 pages, and people don't understand that courts today are looking at every paragraph, and they will pick up anything that could be an inconsistency or could lead to something not being clear, something being vague and ambiguous, and they will find that the release and waiver of liability is void. So you, as a business owner of one of these kinds of companies, venues, sporting events, fun zones, adventure places, you want to have a more of a simplistic release and waiver of liability, which clearly identifies that the person using your park is releasing you from any and all claims that may happen for any injuries that are sustained there, whether it's for their negligence or your negligence. And the more simple it is, I think the better in today's society. The case law, the Florida courts are going to, they're moving towards looking at these releases and finding them invalid because it evoked confusion in the person signing it. So I think we have to be really careful how these things are created and drafted, and for that's something that we can certainly help you out with.
Isn't the key on those type of documents foreseeability, whether it's foreseeable that the harm could happen?
Well, in some respect it is, but the case law is also pointing out that the key language about any and all claims can pertain to both for anything that happens to you as the patron, where you get injured because of your use of the equipment, or it can pertain to the negligence of the facility. The facility, the business owner wants to ensure that the release clearly identifies that the person utilizing the premises is going to release them for any and all claims, regardless of whether it's your negligence or their negligence, and regardless of whether it's foreseeable or unforeseeable. Those releases can be worded to provide for that.
Yeah, the reason why I was bringing that up, because, like, for example, a trampoline place or anything like that, let's say somebody goes and uses the bathroom. There's something on the floor in the bathroom. Would the release possibly cover some type of negligence like that?
Again, that's what's interesting about the way the case law is developing in this field, because all the paragraphs of a release have to be read together.
Right.
And so you have to look at what is worded above. And if besides the phrase, you agree that you understand this release and that you are releasing and waiving liability against the property owner or the business for any and all claims, you want to make sure that there's something above that explicitly confirms not just use of the equipment, but the property overall.
Being on the premises.
Mm-hmm. And that, I think, would help cover the business against liability.
That's very interesting. Now, I know you're a litigator, but you also draft these agreements, right?
Yes. Through my 20 plus years of experience in this field, I've seen a lot. I've seen a lot of good contracts, good incident reporting forms, good policy and procedures for businesses, as well as good and bad waivers and releases of liability. We can certainly help provide that service to any business owner that needs help in establishing policies and procedures for their business operations, incident reporting forms, and waivers and releases of liability.
Now, Doug, I can't thank you enough for coming on with me today. And if anybody out there is interested in learning more about those documents, or, God forbid, they have a claim being made against them, how can they get in touch with you?
Well, my office for Banker Lopez Gassler is located in Plantation. We are a statewide firm. Our primary office is in Tampa, but we've got 6 offices throughout the state. My direct office line is 954-440-1333. And you can find us on the web at bankerlopez.com.
Just bankerlopez.com.
Well, www.bankerlopez.com.
Excellent.
Yeah.
Excellent. Well, again, this has been a lot of fun for me, because getting to pick your brain is always fun. And I do that from time to time, just on cases I have, and to see what you think, and vice versa. And
Absolutely.
I'll continue to do that. I want to thank all of you for being loyal watchers, listeners this year. We are going to conclude the first season of Questions for Lawyers next week with 2 shows. The first one is going to be on June 18th with Justin Pearson for the Institute for Justice. He's a constitutional lawyer. You know, those are always great conversations right there.
Yes.
Justin represents small businesses who need to sue the federal government for one reason or another for regulation. And it's going to be an amazing conversation. Deals a lot with food trucks and things like that. And then I'm going to have Michael Minardi on June 21st, who I went to law school with. He's a criminal defense attorney in Tampa, and he is spearheading the marijuana legalization movement in Florida. He's very involved in that with medical, recreational, and is a wealth of information. And, you know, regardless of what side of the fence you're on for that issue, it's going to be a fascinating discussion for our last one.
Very interesting stuff.
So I want to also give a shout out. Today is my wife Jessica's birthday. Happy birthday, Jess.
Happy birthday.
Yeah, I couldn't let the show go without that. And I just want to remind everybody that really all you need is love and a good attorney.
Absolutely.
Good seeing you, Doug. See you next time.
This was great.
I'm Jeff Adelman. Have a great day, everybody.